that are basically that matter to people, because that's why we want to use our Christian's social media channel, and then we have coffee chats to serve the community, serve the society. So you're welcome to get in touch with us also. Yeah. So now, if I think first what we'll do is we'll go with the questions that are on the chat. Those who want to raise their hand on Zoom reaction, please hold on for a moment, a few minutes, and then we will. Okay. So let's do it systematically so there's no confusion. Okay. Now, expectation. What are the benefits of self redevelopment? Builder managed self redevelopment or over redevelopment to builder? I think that was clearly explained by Advocate Floyd. Can an individual family plot be developed through the builder and developer?
1 second. Let me just, can I pull up this chat if possible?
Yeah, it's there on the open chat. I'm just reading out to you. Can an individual family plot be developed through the builder and developer?
Yeah, of course. As long as all the family members are consenting,
Okay.
there
Is
shouldn't be an issue.
yeah, is members corpus apart from society corpus a common practice?
See, these are all subject matters of discussion. So this is how you negotiate. So sometimes it's only members copy, sometimes it's a society copy, sometimes you could have, a split where it's both. So it's purely a subject matter of negotiation.
Okay. Typically, how many times will assessment and maintenance go up after redevelopment of a 50-year-old six-story building to a
That you need to check with
three-story
your
tower?
architects because you'll have to see the depreciation that you are getting, and based on that, you'll need to check your land records for that, your assessment for that.
Okay. We had given a property to the builder for redeveloping. However, he has not paid the rent for the period. The place was under redevelopment, but the flats have been handed over to us, but we have not. But he has not abided by the payment of rent. Also, he has not given one of the family members a place and is now on the run. What do you suggest? How do we proceed? Thanks. Did you get it, or should I
Yeah,
read
no,
it
I'm reading
again?
it off from the screen. 1 second.
Okay, okay.
So you'll have to effectively go to court for that. Issue a notice to the developer, um, to whatever extent of non-compliance has been done. Um, basically asking him to comply. If after that he still doesn't comply, then there's no other option but to go to court.
Okay. Any thumb rule for deciding the amount of corpus? Is there any thumb rule?
Not really. Again, it
Okay.
all purely depends on, it's very subjective. So it's purely on the basis of what you've negotiated and how you've negotiated. Again, I mean, you would want to consider what kind of a building is being put up, and what are the features, facilities, all of that being, done. And according to that, you want to consider how much of corpus you want to add in or not.
Okay. Rent to be given now is for 3 years. Is that the standard now? I mean,
See, most of the
just
DAs
asking.
are 2.5 years with I mean, 2 years with an extension for 6 months, or
6 months.
2.5 years with an extension of 6 months. It would either go to 2.5 years in total or 3 years in total. Again, it depends on the
Okay.
size of the project. It depends on, the developer and how accurately and how fast he plans to complete the entire project.
Okay. Fixtures and fixing to be added in DA or PAAA.
It depends how you're documenting it.
Okay.
Because
Two.
if it's certain owners or whatever, like if it's the question that came in earlier, where they are property owners and not a society, they would not be PAAs, so they would be only a DA. So in that case, you add it into the DA. In cases of societies and other places where you have a PAAA in addition to the DA, then of course the individual furnitures and fixtures and other fittings can go into the PAAA.
Okay. Two housing societies have decided to go for joint redevelopment and have done MOU between them and passed resolution in their respective AGM. Both societies are on collector land. When is the safest approach for the two parties to merge before the redevelopment or at the time of OC? What are the risks of joint redevelopment?
See, first of all, for this, you'll need to. So this is why I said, at certain points you would need to consider having your own this thing, own councils on board, or this thing, having your own legal team on board. Because what happens is, see, when it's collector's land, you'll have to see the terms of the agreements and all of that, the terms of lease.
Okay.
And whether it is possible to merge it. If it is possible to merge it, there will be specific provisions with regards to that. So these would have to be taken up specifically with respect to the plot.
Right, right. Okay, I think for anybody just wanting the PPT, you could just go back to our channel also and take the photographs from there. Yeah.
Can a society
NMB
forcefully
Coffee Chats
evict a
YouTube channel.
tenant if the tenant is in compliance with the again, if you're saying it's a society and a tenant, meaning how does, if it's a cooperative society, you would have members. I don't think you would have tenants in a
Yeah.
society unless it's a tenant cooperative.
Okay. Now, before we return back to the questions on the chat, we'll take some on the audio. Yeah, Rosie, please go ahead. You've raised your hand, Rosie Coley. Please unmute and ask.
I'll also ask a question, Pastor G, to Advocate Floyd. Now,
Okay. Yeah. Fine. Go ahead.
Some builders, 5 years, 15 years, they're still paying the rent, and the flats the houses are not getting ready. What can be done?
So now it depends. If your property is prior to RERA, if your DA is prior to RERA and it's RERA registered, you can either go before RERA or you'll have to move a civil court for breach of the DA.
A friend of mine, her flat is not ready for 5 years. So OC they are not getting. So what do you think must be the
That you
matter?
need to see the reasons for decline of OC. You'll need to check with a chartered accountant. I mean, with an architect, because what happens is you'll need to actually assess why the OC is being delayed or why it's not being granted. There probably would be some non-compliance or something which needs to be complied with.
Okay.
Okay, thank you.
Yeah.
You're welcome.
Any other? Okay, I think let's go back to the chat. Can you explain corpus funds in detail?
You've covered that adequately, but
You've done that. Okay, yeah.
corpus
Go back to
funds
our NMB.
basically just to cover the buffer in expenses or increase.
Right, right. In case of self-redevelopment of piece of land, what are the rights of the owner and what factors are to be protected so developers can do no fraud or cheat, like how much carpet area is allowed to obtain by the owner, etc. I think the Advocate Floyd has explained that in the video.
I don't know what this person really means, because actually what happens if you're doing self-redevelopment, you are in control, so the developer can't cheat you. There is no developer, first of all.
Correct.
So
Yeah.
I'm not really clear on the question actually.
Yeah. Yeah. So we have to be okay. In our society, few people live abroad. Is Zoom voting in redevelopment valid?
I mean, if they have no option, I mean, you can use Zoom. There's no official exemption or this thing.
Okay. We had given our property to the builder for redeveloping. However, he has
Just
not.
can I just just to add one thing.
Yeah, go ahead, Derek.
In that previous question that you asked about Zoom, so therefore, if the assent is given on Zoom, does it have to be followed up with an email just to keep it in writing? Is it better to that?
It would always be better, because see, at the end of the day, what would happen is you'd need to have some sort of documentation. Now, the 79A meeting, when you have the SGM under section 79A, the meeting is supposed to be video recorded.
Got it.
So, of course, Zoom also allows you recording, so there is no issue per se, but it's always better to have everything, documented to that extent.
Thank you.
See, anyway, at the end of the day, irrespective of the Zoom meeting, you're only using the Zoom meeting for consent. But effectively, what happens is when the DAs, when the MOUs and other documents are signed, that person abroad will have to either come down and sign it, or will have to generate a power of attorney for somebody here to sign it.
Understood. Got it.
Because finally, see, at the end of the day, you require a registrable document.
Got it.
The Zoom is only for consent, no? I mean, at the end of the day, you require a registered document.
Right. So therefore, your first point where you said ownership of the existing ownership has to be clear, that I think is critical first before we enter into this. Because if ownership is not clear, then who's signing?
If ownership is not, yeah, of course, that has to be, the titles have to be clear.
Yeah, no, exactly. You gave an example, right, of the mother and the sons and the thing.
See, because all these things, what happens is if it's not done correctly, then you are inviting trouble, because then there is going to be disputes, and then and see, that's with respect to the flat, it's
Great.
okay, it's one flat that goes into dispute. But if God forbid you have an issue where the dispute is regarding title, and then somebody goes to court, that's the time when your project gets stuck, because if there's a stay passed from the court, what will you do? You can't do anything. You'll be bound by
Absolutely.
the order.
Absolutely.
Right.
So that becomes an
Okay.
issue. So that's why also when we were talking about consent, I mentioned the more consent you can get, the better it is.
Okay. Yes, Rosie Coley, we had asked you earlier. Please go ahead, unmute and ask your question.
Thank you, sir. There was some internet issue. So my
Okay.
question is there, how can we see a conveyance deed reflect on our papers? The ex office bearers are not showing. So in a audit report, it doesn't reflect on the assets. How can we find out? And second question is there, without the audit report's approval, can we go for the redevelopment? Because they say our reports expenditures were spent by them, and they themselves don't agree with their audit report what the government panel
See,
auditor
the
did.
audit report, again, it's better if you can get it done, because what happens is, again, when the society hands over, you'll have a newly formed society. It always makes more sense to have everything in order, because you will have to eventually hand over the entire books of accounts and the society information, documentation, accounts, everything to the society when it's newly formed, because there'll be a society formed once the redevelopment is complete. New meaning it will take in the new members, etc. You may not have a new registration, but the newly formed body would have to have the records of the previous body, because
No, our society is an old society, sir, and they had resigned, and now
correct.
the
But then when you
documents.
hand over in future, you would
Yeah,
require the
yes,
documentation in order. No? So if you're going in for
yeah,
redevelopment, now you're going to
yes,
take
yes,
in new members. When you take
yeah,
in new members, if the existing accounts are already a problem, then you're going to get in new members. You're going to, of course, increase your problems.
correct, correct, correct,
So it's
correct.
always better to have it rectified prior to going into redevelopment.
And for conveyance deed, where we can see they are not showing the papers and all. So where we can see whether the conveyance has been done, they are telling from 18 years that it is done, it is done, it is done, but it doesn't
The
reflect
simplest way to check it is check your property card, because if the property card has been updated, then the conveyance, the property should show in your names.
property card is
Okay.
also not there. It's not there. In 2023, I got from the Ajmera builders all the papers. Till that, it was not done. Went to the property card, it is not done. They say it is not done. And if we are getting property tax in the old member's name, who was a Parsi who has buy, so that means it is not done, na? Property tax when we are paying. If everything is done, it should be in our society's name.
Yeah, so it's a
I think.
possibility. See, but that can't be concluded that you'll have to check all the papers, because what could have happened is the conveyance may have been done, but the property records or the assessment records, because they're separate departments. The property card
Okay.
is a CTS office. The assessment comes from, if you're in Mumbai, from the municipal corporation.
Mumbai,
So
yeah.
Right.
And they invest. And
sometimes
they
what
invest.
happens is the conveyance is done, but the CTS records have not been updated. So after it's not automatic. When your
Right.
conveyance is registered, you have to make an application along with the copy of the conveyance to the CTS office to have it updated in the CTS records. That is when your property card gets updated.
Okay. Thank
Okay,
you, sir.
then on the basis of the property card, you have to go and update your this thing assessment with the corporation.
Yeah, property card
Okay.
we don't have. We don't have property card. Thank you, sir. Thank
Okay,
you
you're
so much.
Okay.
welcome.
Okay.
You're welcome.
Yeah. Friends, let's not try to mention any specific builder's name or society's name because this is just for queries. Let's not use it to, unnecessarily tarnish someone's name or reputation.
This is
Okay.
Riaz.
Yeah.
I
Riaz,
had
you'll
a
have to wait.
okay.
Riaz, you'll have to you have to use your Zoom reaction, please. Let's have some order, and according to that, we'll come back to you. So raise your hand with the Zoom reaction. In an AGM recently held in a society, forcefully validity Zoom voting was passed. Is it legally accepted in redevelopment of MADA or building acceptance?
See, today's Zoom, I mean, you can use it for voting. That's not an issue. There's nothing that bars it. Documents again would have to
Okay.
be signed. If you're saying legally, if it was forcefully, I mean, I don't know, I understand what is this. If it was forcefully obtained, then that should be challenged.
Right, right.
That you go to the deputy
Okay.
register, challenge it.
When there are dissenting commercial members, when do the residents who have signed vacate the premises? Is it after their dispute is settled or after vacation notice, vacating notice?
Descending commercial members. So you're saying the society has, is this person available? I mean, if you're saying
Yeah.
it's a society where you have, mixed membership, some commercial residents maybe on shops below or something, and then the residents above. Either way, I mean, the dissenting members, that would be at the pre-DA stage. That's when you're getting your consent. Once the
Okay.
DA is signed, I don't think you will have dissenting members, because if the majority has voted in favor of, you'll go by majority vote.
Okay.
And
Does
the vacation should happen only after, at least at or around the time the IOD is obtained.
okay, does current use of FSI against available determine whether to go for self or redevelopment?
So that is the reason why I said you have to get a feasibility report, because that's where your architect will individually assess it, because there are several factors when you determine this, and that needs an entire professional opinion.
Okay. In our society, about 30% of the members are non-residents and give their flats on rent and attend the meeting on Zoom. Can their votes and attendance be considered? I think,
Yeah, as long as they're bona fide
yeah,
members, yes.
right, right. Okay. Yes, Riaz, please go ahead.
This first
100%, yeah, sure.
query on
Riaz.
self-redevelopment. We have members who've given consent for redevelopment. We have a majority of 57% right now. Because of the concern of the delays by the developer or faulty construction, we are assuming that if we had the opportunity to go for self redevelopment, those members would also be willing to agree for redevelopment to get a higher percentage of approval. But we may still not get 100% approval. Can a housing society start redevelopment or self redevelopment even if it has less than 100% approval?
Yeah, you need 51%. As long as you have 51%, you're fine.
Even for self redevelopment.
What I said is, you require as much consent as possible to avoid glitches or problems in the development process. 51 is what is statutorily required. If you have 51%, you can provide this thing. Simple majority is the term used.
Yeah, even for self redevelopment.
For any development.
Okay.
Yeah, okay. Do we need 100% consent for doing self redevelopment of society?
That is what we just answered.
Yeah, correct. How would a person go for redevelopment in a Gauthan area, as in terms of road access and road widening?
Apply to the corporation.
Apply to the
If you
corporation.
don't
Okay.
have, see, the minimum road width you require is 6 meters. If not, you'll have to apply. But again, Gauthans becomes a little difficult because most of the roads are under 6 meter.
Okay.
So it becomes tough.
Yeah. What if in a 79A meeting, physical quorum required is not there, so Zoom votes can be considered as quorum?
Yeah, of course, no problem.
Yeah, okay. Thank you. Yeah,
You're
appreciating
welcome.
this wonderful session. How to handle the situation if there is no occupancy certificate for a gated community? Do we need to occupy the flat or not? Please clarify. Thanks a lot.
See, legally speaking, until an occupation certificate has been obtained, whether it's a flat, or whatever structure it is, even if it's a standalone, row house, bungalow, whatever, until an occupation certificate has been granted, you're not legally entitled to occupy it. That is the settled principle in law.
All right. When there is an existing society, will it continue post the construction of the new building?
Will it? Yeah, of course. The society will continue. The persons who buy flats in the sale from the saleable component, they will be added to the society. Of course, there may be a change in share capital, and there'll have to be reallocations of shares and all of that. But other than that, yeah, of course, you don't need to re-register a society.
So sorry, that question was mine. So will new share certificates be issued?
To the new members, yes. The old members can continue. But if you're reallocating the shares, then you'll have to issue all new certificates.
Okay, so if they're already 50, if they're 50 a share and the adequate authorized capital, then you don't need to change it. So
then you don't need to change it.
Understood. Thank you.
Okay.
Perfect.
Is only PMC advisable or better to appoint legal advisor?
I think that I've already discussed. I mean, first of all, you have, with all due respect, you have an agreement with PMC. So before you sign your PMC on, who's going to check that agreement?
What happens to society once a building are any maintenance payable during the reconstruction?
No.
No maintenance.
Once you hand over possession to the developer, everything is, the developer's responsibility right up to the time he hands over the completed flats back to you.
Okay. Will same old MC continue? Yeah, I think he already answered. Tenure of MC expires during redevelopment. What happens?
A tenure of MC is sacrosanct. So once your 5-year term or whatever term you have as per your society bylaws expires, you have to reconstitute the MC, even if the building is under reconstruction at that point in time.
Right. If a builder
Which
is
is why,
unwilling
I had mentioned this earlier, but this is a thing that you can consider in terms of a suggestion, which is why most societies appoint a redevelopment or self-development committee. So that committee it will have MC members in it, but it will also have a few fixed members in it. So at least, you have that committee as a constant till the entire process is over.
Okay. If a builder is unwilling to share their financials, should it be considered okay?
No, that's okay. If the builder doesn't want to share it, I mean, you can do your due diligence, which is why I said you have a professional, your chartered accountant and your lawyer will be able to take it off.
Okay. In case of self-redevelopment of piece of land, not society, what are the rights of the owner and what factors are to be protected so developers can't do fraud or cheat, like how much carpet area is allowed?
So this is basically goes to your documentation. See, there is no way you can, I mean, when we talk about documents, and this is what we're very clear with in terms of all our clients also. There are two aspects to fraud, and there are things which are negotiables and variables which are within your control, and then there are factors beyond your control. Okay. So whatever can be, pre-discussed, pre-decided, and that can find a way into your documentation, that should be done, because if it's not done, then of course you're exposing yourself to risk. Now, factors beyond your control, something goes wrong subsequent to the signing of the DA, that you can't preempt at the time. Like suppose, for instance, I'll just give you an example. At the time I'm drawing up at the time you are drawing up your DA, or prior to drawing up your DA, when you're doing your due diligence on the developer, you have done your due diligence. Now there are no cases pending against the developer. There's no bankruptcy proceedings. There's no insolvency proceedings. Nothing. No DRT matters. No high court litigation. No RERA matters, or maybe one small matter or something. Now it looks clear. I mean, prima facie, it looks clear when you look at it from a legal and an accounting standpoint. However, factors beyond your control developed subsequent to the signing and execution of the DA. At that point in time, if suddenly the builder goes bankrupt, that is beyond your control. Which is why I say whatever you can do, you should do. Beyond that, I mean, there is always an element of risk.
Right.
See, nothing is risk-free. I can always say, traveling to office is so risky that I'll sit at home, and what if my building collapses? I can die sitting in the house. So, I mean, I tried to circumvent one risk by exposing myself to another.
Right.
So, I mean, nothing, in that sense, nothing is foolproof.
Very true. Yeah. Most buildings which have been redeveloped in a Gauthan do not have OC and people have occupied their flats. What is to be the risk factor?
Which Gauthan is this, if I may ask?
Which has been any Gauthan.
Very specific, because I'm aware of the Gauthan issue since I'm handling that PIL in the High Court. So that's why there's a specific Gauthan I may have info on it.
Yeah, you could connect with Advocate Floyd later and discuss. Is there a working or conversion from MOFA to RERA carpet area?
See, there are variables, but yeah, I mean, the PMCs generally have their standard computations.
Okay. What if fixtures, fittings, and internal flat amenities are not in agreement? How to get it into registered agreement? I have already paid 10% and charges for registration SD, but not one for registration of flat. Now they are asking 20% of registration. What to do? Please advise.
So amenities, if the final document is not registered, then of course, yes, you can add it in. That's as far as your fixtures and fittings are concerned. 20% we'll have to, I mean, you'll have to consult a lawyer and ask them to see the exact agreement, because I don't know what is the stages of payments. If it's staggered payment, then it's purely up to how the deferred payments have to be made. So that is a matter of contractual agreement.
Okay. All right. One more question. Do we require consent criteria in case of any self-development of property?
Yes. Consent, majority consent is required irrespective.
Okay, what is the decision on the members having to pay 5% GST on cost of redeveloped flat, or should builder pay for it?
So again, normally it's taken care of by the builder, but if your agreement specifies otherwise, then yes.
All right.
So again, these are all negotiables. I mean, this is why I'm saying, when you sit, and this is where your professionals come in. When you sit to negotiate, this is the kind of stuff that needs to be, sorted out prior to getting into an agreement. Otherwise, tomorrow the GST components, or some tax component is not covered, or maybe stamp duty is not covered, or registration fees are not covered in the agreement. And then tomorrow you thought the builder is paying it, builder thought that you're going to pay it, and then that's where you have a dispute.
Right.
It's the same thing, like I was giving you the example for furnitures and fixtures. It's all about understanding the same thing in the same sense. In the sense, both parties or all parties, if there are multiple parties, should be on the same page. It should not be that, one person thinks of it from one light and somebody else thinks of it from another. But then you are, kind of exposing yourself to possible legal risks.
Okay. Thank you. Will self-redevelopment help in avoiding all
Yeah.
these
So
tax
there
overs?
is tax rebates and this thing benefits for self-development.
Okay. Thank you.
In fact, the governments
Okay.
have been trying to promote both at the center and the state. They've been trying to, in several states for that matter, trying to promote self-development, because it kind of gives people direct control and enhances transparency also.
Correct. I think we've reached to the end of all the questions.
Anyone,
is there anybody who wants to unmute and ask directly? Please go ahead. We'll close in the next couple of minutes. How can we get the people? You come to our NMBF Coffee Chats YouTube channel. You will find this recording there, and from there you can access the PPT in terms of taking screenshots of the video.
Sir, I just have one last question.
Sure.
We have already shifted into a flat wherein later on we realized that it is an SRE, and the builders have not yet given us proper this thing, conveyance deed and all, and we have also not received the share certificates or any corpus fund. So in this matter, what is to be done?
So you'll need to see your agreement, because whether you were part of an SRA scheme, whether you were under the non-SRA component, SRA component, whatever, that would have to be analyzed. And then what were the terms of agreement? If there, as per your agreement, there is a violation or a breach, then of course you have legal remedy, which means depending, either you go before the RERA authority or you go before a civil court.
Okay. Maybe you have answered this question, but okay, Belinda, finish.
Yeah, one question, Floyd, in your view, your personal view, a society with 42 members, is it advisable for them to go for self-redevelopment, or should they go for a builder?
You said 42 members. You're not the society I'm representing, right?
No, no.
Okay.
Because it's one which I coincidentally have, which has 42 members. That's why I just.
Yeah, let's not get personal details out on social media.
Just your
This is
opinion
all
in
recorded.
general, and I'm
if
not
it's a
from
matter
any
which I'm
society.
officially connected with, I'll be prevented from making comments on it.
No, we
Right,
haven't
right,
even
right. Let's try to.
gone beyond the AGM. We have not even called the general body for redevelopment. We
Yeah.
are at an early stage.
Okay. So, yeah. Okay. Let's go ahead. I think. Yeah. What is the minimum number of members needed for, I think, redevelopment or self-redevelopment? I think. Is there
51%. 51%.
51%.
Simple majority.
All right. Okay.
Is there a GR on Zoom? Not to the best of my knowledge.
Sorry, just to reclarify that, it's got to be 51% of the members, not of the 51% of the people attending the meeting, right?
Yes.
Yeah, 51% of the members.
Yeah, okay. Right. Next question. Has there been any GR issue regarding inclusion of Zoom voting for
No,
the
not to the best of
redevelopment?
my knowledge.
Okay, what about the flats which are locked and the owner cannot be traced? I think it is about
Okay.
coming to a decision.
Yeah, in
If
that case, you'll have
owners,
to take it without them, this thing,
all right, okay.
without their consent.
Fine, please unmute and answer. We will close in few minutes. And I mean, ask your question. That is,
First of all,
I
thank
want
you
to
for
ask one
organizing this thing
question.
and sir, Floyd,
Sorry.
fabulous.
Thank you
This
so
is
much.
yeah,
really great. On behalf of everybody, thank you very much.
Thank you. It was a pleasure.
really.
Hello.
Okay, anybody else?
Can we ask one question? No.
Yes, Mildred, go ahead. Yeah,
Oh,
go
that's
ahead.
right. Can you tell me if you are in a redevelopment of a society, before it goes in, do you get an allotment letter? Is it allotment letter is a
No,
must?
the allotment letter will come subsequently because first you will have to sign your DA. Without a DA, there'll be no allotments.
Okay, thank
Allotment
you.
comes in much later because how can you have an allotment? Because first your DA will come in. Then on the basis of your DA being executed, the builder or the developer will put his plans in. He has to get his IOD. Then there's the whole lot of construction compliancing that needs to be done. Only after that can you actually start talking about PAAs and allotments and stuff like that.
But you must get an allotment letter. That's what I'm trying to find out.
Not necessarily, because if you're going as per the DA, I mean it's pretty much covered in the development agreement. So there's no specific necessity to.
Floyd, related question. You said you can vacate after the IOD comes in from the developer, from the
From
municipality.
the corporation, yes.
The question is, at what time do we need to sign the PAAA? Is it advisable for
PAAA
me
can be signed subsequently. There's no issue.
subsequently? Can I, like, if I am very nervous, can I insist that I want to sign the PAAA before I vacate my flat?
If the builder allows, it's not a problem. But I'm not very sure. I mean, how many builders will actually be comfortable with that? Because see, once the DA is signed, then they start their processing. Now, if you commit to a certain thing and then the plans change, it becomes very difficult for the developer to commit.
Yeah, so I also want to know precisely which flat I'll be moving into before I vacate. It should not be in the air and later on I find out
But
that.
how can you? Because what happens is, at the time you are getting into your DA, and even at the time the IOD is done, the plans may be subject to amendments also, no?
But in principle, the layout of the floor and the flat sizes will all be, logged in the plan.
See, your area will be mentioned in your DA because as per this thing, I mean, if you're getting a 27% appreciation in area, your existing area plus 27%, that will be covered in your list of
front
members.
side, back side, view, floor.
Yeah, so that you need to negotiate, no? Because that your society will also negotiate, we want front facing or side facing.
Yeah, because what I was anticipating is that there would be a sample plan, may not be the final approved plan of the building floor wise.
See, but if you're going into that, then there will be a representation made that it was a plan just for representational purposes. Now tomorrow, if that plan changes, your contract does not become enforceable. Your agreement falls.
Yeah, but it will be the changes have to be relative. It can't be like if I was I'm currently on the 3rd floor. I was promised to go on the 8th floor. He's going to put me back on the 3rd floor in the new building.
So generally, yes, but then all these again are subject matters of documentation.
Yeah.
Now,
Okay, I
certain
think
things
that's
can't be negotiated, but of course, yeah, if there's a floor-wise consideration or something that you probably, looked into at the time your flat was taken in, you would obviously want and expect the builder to respect that when you get into the new project.
Because see, what I've been told by lawyers is that, like, today you have the sale agreement for your ownership of the title of the flat. Once you vacate and you hand over the possession of your flat to the builder via the society, then you no longer have a title to anything. So unless you've signed a PAAA, which is your next title or ownership document, you don't have ownership about anything for that interim period then.
okay.
True, but the issue that comes in is, see, there has to be something tangible.
Okay.
See, at the end of the day, when you're transferring a property, there has to be a schedule to that property. There has to, it's something physical. Now you're saying, I don't want to get a flat in air, but if the plan is not made, any commitment made on the PAAA also is a flat in air only.
Yeah, but
Okay.
PAAA is my title and ownership document through
Your
which I can
title
take
is also
it to court.
created in the development agreement.
It's also in the development agreement.
Correct. But the thing is, see, you cannot have anything specific until the thing is definitely being made. See, if I tell you this pencil, okay, I'm selling it. You can see this pencil. There is a pencil which on payment I will hand over to you.
Right.
But if this pencil is not even manufactured, how can I commit to it? And then tomorrow, what happens if the shape size differs? You will tell me I have not matched the expectations.
So typically after the IOD, how much time should I wait for the builder to get the final approved plan?
See, if you're an existing member, you should not really sweat that much, because what happens is you will have a DA in place.
Okay. This is going back and forth now. Let's not do that. You can contact Advocate Floyd afterwards. Okay. I think there's another question which is probably connected to the same thing. How are the flats allotted in the new building after the development? Is there any system? Again, that is all in the documentation, right?
It's all
As
in the
you mentioned.
documentation. But if
Yeah.
there are preferences, then it's always, pushed into the DA. Like, if the existing members get a certain preference to front view or upper floors or whatever.
Yeah. Okay. All right. I think we've come to the close. Anybody still wanting to ask any question? Yeah.
So there are a lot of documents that have been from IOD, and if you could just if in 30 seconds, if you could just tell us what is the sequence of the documentation that normally gets done, that'd be great.
From the BMC point of view or from the
From the
DB point of
entire
view?
project point of view. So basically from start. So the first one would be the DA, right?
First one, if there are MOUs prior to the DA, then of course you'll have the MOUs prior to the DA.
Okay. MOUs, then DA.
Then DA.
Yeah.
If you're doing self-development, then all the agreements we listed on screen, you'll have to get all of those done in almost that order. Thereafter, the builders. So if it's in development, you don't really have much of a problem, because once your DA is signed, the rest of it is all taken care of by the developer.
The builder,
The developer will make his applications to the building proposals department. Then up to the time he gets his IOD, that's all his responsibility.
Right.
Okay.
But if it's self-development, then we have to get the
So then
IOD.
yeah, that's where your PMC then comes in. Your PMC will have to guide you, and both of you, as in the society and the PMC, collectively would have to get all these things complied with.
Got it. Okay.
Then you'll get a building
Okay.
commencement certificate that gives you. So once the IOD is complied with, IOD is the intimation of disapproval. Once that's done, then they give you basically the compliances. You have to comply with that. Then you'll get your commencement certificate. Once you get the commencement certificate, you complete the entire project. Then you have your final plans. Then you have your building completion certificate, and finally, after everything goes through, all the checks are complied with, you'll get your occupation certificate.
Thank you very much.
You're welcome.
All right. Anyone else? Any other doubts or question before we close?
Between this commencement certificate and the final occupation certificate, mostly for redeveloped buildings, the developers try to obtain a partial OC or something, so that the rehabilitation people can come back to stay while they still.
Yes, if they get a part OC, then you can occupy up to the extent that has been granted an OC.
Okay.
So suppose they're doing a 35 floor building or a 40 floor building, and they're done with around, say, 25 floors or whatever. They'll get an OC for probably the first 20 or first 22. That the corporation has to decide based on safety and several other factors that the corporation's engineers will check. And the architect and the construction company would have to certify it in terms of it's safe for habitation.
Okay, there is a question on the chat. How much compensation can we expect if builder failed to get OC from municipality? Please clarify how to quantify the compensation for a floor building.
But that is, you'll have to study the agreement around that. That's what I'm saying. These are all things that need to be professionally discussed with your lawyer.
Lawyer, okay, fine. All right, anyone else?
Quick question,
Yes.
actually. After the IOD comes, there are around 2 to 3% of people who are not willing to vacate. Is this something concerning, or should we wait until that matter is resolved and only then move out? Because a lot of people have signed the vacating notice, but not these 2 to 3% of people.
So if they are not vacating, then I mean, you'll have to. It's always better to have the society discuss it with the developer, because is he going to be going to court on this, or how does he plan to evict them?
I
Okay.
don't know actually, but just as a person who is thinking whether I should vacate or not, or just stay in the building until this matter is resolved, that is.
It's really a call
A,
that, I mean, you can take either way,
oh,
really.
okay,
Hello.
all right.
Hello. Is it okay to
Yes,
talk?
yes.
Sure.
Yeah, go ahead, Frank.
Frank, yeah. To avoid, from my view, that this is actually this pertaining to architect. To avoid all the bottlenecks. Thousands of housing societies are installed. First and foremost, every individual should take responsibility. That feasibility calculation to architect plus free FSI, considering 500 square feet, you may get 10% of 500 approximately. Free FSI like built-in cupboards, then windows, this thing, that thing. So many things are there. Free FSI approximately. And then we have to put light on IOD terms and conditions. There are about 36 terms and conditions.
Correct.
That will help with end in mind. You have to go. So once we know our architect, or in case most of the buildings are 30, 35 years old, the architect may be living, may his other people may be the earlier, the erstwhile architect of the building. They may give us free of cost of the FSI feasibility report, or they may charge few thousand rupees, provided he has all the documents, or provided we give him all the documents. It's not a big issue for to give feasibility. But terms and conditions of the IOD are very crucial and very important. Only when we know the terms and conditions, are we suitable for that? If something is there, it's another problem. So we have to see. Then another one is a free of uh, road. Nowadays, illegally people are building on the road, and we are keeping quiet, the housing society. And then when we want to go for redevelopment, the truck also cannot enter inside. We are kept quiet, and municipality has not taken action. This is another bottleneck problem for the official building, the taxpayer versus the illegal.
Okay.
And
All right.
I had a question on DA.
Okay.
Does the DA, when it goes for registration, must it have that copy of IOD? Because like he just mentioned, there are multiple conditions even specified
No, no.
inside
At the
the
DA time, you will not get an IOD.
will not
Until
have
your
that.
DA is executed, you won't get an IOD.
Okay. Second is the DA, should it be signed directly between the society with all the members' signature, or should all the members give their power of attorney to the managing committee?
No, no, no. Everything let each member sign their own.
IOD. See, IOD is nothing but terms and conditions of approximate 36 terms and conditions, appliances, fire brigade, blah, 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 whatever it is. So we have to just.
Okay.
Okay.
All right.
Another question on DA. Nowadays, the developers insist on making a joint venture company or something, special purpose vehicle, SPV.
SPV.
Yeah. So is that in the interest of the members of the society, or we are better off having a direct agreement between like the company's director and the members of the society?
See, SPVs have their own advantage and disadvantage. Now, what happens is if it's an SPV, the liability is only strictly in respect of that company. The problem is if anything goes wrong and that company goes into bankruptcy, the liability is limited to that. You can't take it from the other aspects of the company.
Okay. All right. I think we've reached the end of our time now. And Advocate Floyd also, we've graciously given his time so freely and answered a lot of questions so freely. But thank you so much for your kind-heartedness and
No, no
your
problem. It was a
graciousness
pleasure.
in giving this time. And God bless you. And friends, please, if you want to get in touch with us, do that with the connections given. And also, I think you can easily find Advocate Floyd Gracias social media handles on Google, and you could connect him with him through LinkedIn or something. Okay. Thank you all, and God bless you.